So far, we've only discussed statutes, yet any legal code can only cover precise topics, and no state has attempted to codify all possible legal questions into statutory form. Judges themselves have, for centuries, filled in the gaps by developing and refining areas of law basic to society's fundamental organization. States generally adhere to this common law foundation in such fields as contract, property, and tort law. Common law doctrine is based entirely on precedent because they need not answer to a legislature. Judges remain free to reinterpret past decisions in light of changing circumstance. And should the legislature feel dissatisfied at any point with the judicial common law formulation, it can simply reverse or modify existing case law by statute. Federal law. It must be borne in mind constantly that the principles underlying federal law and the federal system's organization differ radically from those operating within the states. While states have general power to legislate in all areas except those specifically withheld by the Constitution, the federal government's very existence is limited to explicit constitutional grants of power. Hence, federal law is better thought of as interstitial rather than general. Congress cannot pass a law on any subject unless it can trace its authority to a specific provision of the Constitution. Most such provisions can be found in Article 1, and to the delight of eager lawmakers, are quite broad. They include the power to lay and collect taxes, borrow and coin money, regulate commerce, establish post offices, regulate standards of weights and measures, create courts, declare war, create an army and navy, provide for a militia, set up a government for the capital district, and adopt laws concerning bankruptcy, naturalization, patents, and copyrights. A diverse smorgasbord, though hardly sufficient to fully regulate a society. The 10th Amendment puts the brakes on federal lawmaking power, reserving to the states all powers not expressly delegated to Congress. But when federal power to make law does exist, it supersedes state laws and constitutions by virtue of the Supremacy Clause of the U.S. Constitution, Superscript 7, which reads, Article 4, Section 2. Back to the text. Federal law thus rides roughshod over its competitors, but only within the narrow corridors where it is permitted at all, and only to the extent that it avoids conflict with the U.S. Constitution. Most federal law is statutory. There isn't much federal common law around these days. In fact, federal courts aren't supposed to fashion their own law unless it's absolutely necessary. Superscript 8, which reads, if you're interested in why, have a look at Erie Railroad versus Tompkins, 304 U.S. 64, year 1938. Back to the text. When they do, though, federal common law has the same force over state law as a federal statute, but it can be overruled by Congress.